A very warm welcome to this lesson on trade unions. So what we will be seeing in this one video is that we will be looking at the entire syllabus relating to trade unions. Okay, so this is one long video which will cover almost all of your needs relating to trade unions. Take the luxury of pausing this video every now and then. So let us say I have displayed something on the screen that you wish to look at again. Please do pause the video. In case there's something that I've displayed, I expect you to pause the video, and instead of wasting time for you to read along, I'd just expect you to pause and I'd move ahead. Also keep a copy of the Bare Act with you, because I will make a mention of some sections every now and then without entirely making you read them, because we have a video here and you can open the Bare Act and refer to those whenever any provision is cited. Also, the speed of this video may either be too fast or too slow. You can take the luxury of either speeding it up on YouTube or slowing it down to suit your preference. Okay. To begin, I'd like to give you an overview of what you will receive in this video, or what we will be discussing. We will start off with a few preliminary concepts. We'll talk a bit about what Marx has to say about this, about trade unions. We'll talk a bit about status and contract. We've already had a brief discussion on that already. And of course, we'll have a look at a couple of events in India. We have also spoken about this, but I'll quickly repeat these with you in this video. Next, we'll have a look at trade unions in India, a brief history of how trade unions have developed in India, and also some of the major trade unions that presently operate in India. Once we are done with that, we proceed to have a look at this entire debate between the individuals and the collective. So, what happens to individual disputes? What happens when there is a single workman or a small group of workmen? What happens? What is their plight? Next, we also realize that there can be disputes between unions. As we will see, unions represent different ideologies, and therefore there can be disputes between unions. We will talk about that as well. And then we talk about some of the provisions relating to the individuals and the collective, right? Once we're done with that, we move on to the Trade Unions Act. And in the Trade Unions Act, we'll look at a couple of provisions that we need to know. Then we reach the topic of dispute resolution, as to how dispute resolution happens. So we understand that trade unions are about collective bargaining, and we look at some of the stages that exist in collective bargaining. We also look at the various kinds of protests that can take place, and we try to get some meaning of each of these. In particular, we will study strikes in some greater detail than the others. Thereafter, we realize that in these rights that have been given to strike, these emanate from the right to freedom, but these also have some restrictions. So we will look at a couple of constitutional conflicts that exist when we talk of these rights relating to trade unions. Then of course, we look at the 6 cases that form the part of your syllabus, that constitute your syllabus. We will see them in quite some detail. And then finally, perhaps we will go for a summary of each one of the provisions and the cases. Now that we have an idea of what we'd be up to, let's start. So as you can see, a union appears to be something that is quite of use to a workman, right? We are aware of what Karl Marx had to say about the society, especially about the industrial society. So according to him, there is always a class struggle that happens between the workers and the capitalists. So he considers the workers as the proletariats and the capitalists are the capitalists or the bourgeoisie. So he says that the trade unions represent an instrument of the class struggle between the workers. So he says that the trade unions operate as this instrument that represents the struggle that always takes place between these workers who are the masses and the capitalist who owns the resources. In fact, one of the cases that we will be studying in detail eventually is this one. He makes in this judgment a mention of the advent of the Industrial Revolution, right? And because of this, it led to a condition where there are many workmen who are at one place under one employer. So now these corporations have immense economic power, and as a result of this, the workmen are at the mercy of the employer, right? He goes on to say that it was sacrilegious to think of a right of a workman qua the employer. Till the laissez-faire ruled the roost, the state would not interpose itself to protect the underprivileged and the weaker partner. So the laissez-faire basically means that there is an invisible baton and that things take care of themselves if you let them take care of themselves, which means that you left the workmen to fend for themselves, and the state concerned itself only with the problem of law and order, which means that when we are talking of a laissez-faire economy, the governmental interference is minimal. Now, the laissez-faire is predicated upon an assumption which he calls untenable or wholly erroneous, because he says that the society, that the premise is that the society has moved from status to contract, which is perhaps an erroneous assumption. The assumption that the employer and the workman would by negotiations churn out a contract that is mutually beneficial was an erroneous assumption. What they have ignored is that the two parties are unevenly placed, and therefore a contract between them is highly unlikely to be mutually beneficial, right? So when we talk about status and contract, what we are essentially saying is, I will talk about that in a bit. So when we talk about status and contract, status and contract. Now this is a quotation by Sir Henry Maine, and I'd like you to look that up. So he says that all progressive societies are moving and shifting from status to contract, which means the identity of a person, of an individual, is now not so much governed by the tribe that he belongs to or the family that he belongs to. Instead, it is upon his individual identity and his capacity to contract, which means that as a society becomes progressive, you rely less on your status in the family or your status in a group, and you rely more on your individual capacity to contract, right? But what we saw in the previous slide and in a couple of more slides ahead is that to believe that we have shifted from status to contract, as is what he says here, to believe that we have moved from status to contract is perhaps an erroneous assumption. Also, when we look at a combination of workmen, English common law, which is where we have derived our law as well, because as you can see, the Trade Unions Act is also an act of 1926. So it will in some way perhaps reflect the sentiment of common law, right? So in English common law, perhaps these words ring a bell for you, common object and this combination as criminal character. You might remember that there is this offense under IPC section 149 where an unlawful assembly having a common object is given a criminal character, and therefore you can see that there is a certain liability that is pinned upon upon a combination, even from the criminal perspective. We look at this statement by Chandrasekhar Iyer. Like I said, please take a moment to pause the video every now and then. This video will be very fast. If you pause the video, you will give yourself an opportunity to read some of these excerpts that I have given for you in these videos. Chandrasekhar Iyer says that we have to see these conflicts between capital and labor. As Marx said, that there is always a class struggle, so there's a conflict. These need to be determined from the standpoint of status rather than of contract. Read the statement and try to make some sense of it by your own self. Again, I'll give you two quotations that we have of Professor Otto Kahn Franz. He talks of the contract of employment as being seen in the eyes of a lawyer. So when a lawyer sees them, he thinks of this contract as a contract between equals, without discerning the true nature of the employment relationship. That is, the power to command and a duty to obey. So what he says is that, let us say we have these two people who have decided upon a contract. He says that they assume that these are between equals, when the reality is that on the one side you have this worker and on the other you have the employer. The employer has the power to command and the workman has a duty to obey. And therefore he says that to label this a contract, to label this a contract is essentially only verbal magic, right? Again, I talk a bit about what was said by Otto Kahn Franz in his, well, this is a Hamlin lecture. It's misspelt, but I've taken this from the Judgment and therefore I didn't change the spelling. It's a Hamlin lecture. So these are lectures that have been happening since 1949 in England, and these are annual lectures that happen. You find these lectures available for free on the Supreme Court of India website as well. So when you do get the time, have a look at these lectures. These lectures are some of the most prominent lectures on law. So in his Hamlin lecture, while speaking about the laws relating to trade unions and labor law, he said that this was an attempt to infuse into a relationship of command and obedience So this was an attempt to infuse law into a relationship of command and obedience, which means that until we had the laws relating to labor, which means before you had the labor laws, it was essentially a relationship of command and obedience. As we saw here, these people have a relationship of command and obedience even if there's a contract. But once you introduce some law into this, it infuses law into that. And he says that to that extent, the law limits the range of the duty of obedience and enlarges the range of its freedom. And that is the object of labor law. Again, we'd spoken of some events in India when we spoke of Champaran, which happened in 1917. And Gandhiji had helped the plantation workers to unite and then have a bit of a revolt. He also found some success in 1918, where he repeated the same with the textile mill workers in Ahmedabad. Having worked with these workmen, he realized as to how important this task force was even for the independence struggle, the freedom struggle. Another very important event that you could perhaps look over is the Bombay workers' strike of 1936. It's the famous one-day strike. And you had over 2 lakh workers from across different areas of work who went on a strike simultaneously on one day. So these are some important historical events that I'd like you to Google. that I'd like you to have a look at and gain some perspective on what caused the labor movement in India to rise. So there are political reasons and several other reasons which you will get an idea of when you look at some of the events that have transpired in this country. Now we have a look at trade unions in India. These are a few statistics. As you can see, again, make sure you pause the video every now and then. I do assume that in my speed you do realize that you have to pause the video and look at anything that I really don't speak of while we are having this lecture. So the Madras Labour Union is one of the first unions, and today we have more than 84,000 registered trade unions. So what that means is we also have some unregistered trade unions. So we have quite a lot of trade unions, numerous registered trade unions, and even more unregistered trade unions. What is registration? I'll talk about it in a bit, don't worry. Again, post the First World War, there was a lot of exploitation of labor, and that necessitated labor unions to be formed. So you had the Madras Labour Union, the All India Trade Union Congress. If this looks like the Congress to you, you are right. We will look at why it is called the Congress in a bit. And we had a couple of others. And in 1926, of course, given the pressure that happened from all of these trade union movements, the British were compelled to enact this Trade Unions Act, which would grant some liberties to these trade unions and thereby kind of quell their protests by giving them some immunity and some power under the Trade Unions Act. Now, when we talk of trade unions today, the Bharatiya Mazdoor Sangh is the largest trade union in India. Again, when you see Sangh, if it rings a bell, you are right. We will have a look at what it is in a bit. So we have some of these trade unions, which is the largest. Yes, you should know that we have really large trade unions. Okay. So we have these trade unions, Central Trade Union Organizations, which are called the CTUOs. Now essentially what these are some of the trade unions, which are 12 in number. You have totally 12 such trade unions, which have been recognized by the Ministry of Labour. Okay. Now what is the meaning of recognition? I'll talk about it in a little while, but for the time being I want you to know that there exist several trade unions, prominent ones with huge membership, and they have political affiliation. So if you see the Sangh, indeed it is the part of the Sangh Parivar and has to do with the Bharatiya Janata Party. Again, like I said, when you see the Congress, it has a political affiliation. When you talk of the AITUC, it is related to the Communist Party, and so on. So just have a brief look at these trade unions. You can Google these up and get an idea of what these trade unions do and as to how they further political interests of the parties. Moving on to our next aspect about this dilemma about the individuals and the collective. If you notice, when you have to deal with individual disputes, when you are in a trade union, for example, something relating to a single workman or a group of workmen, then what can you do? So what we see is first the definition of an industrial dispute, right? Now, not 2KK, it's just 2K. An industrial dispute means any dispute between employers and employers, or between employers and workmen, or between workmen and workmen. Now, as you can see, it contains the plural form. It does not say employer, or it does not use the word workman, it talks of employers, and it talks of workmen. So what about when there is a problem relating to an individual or a smaller group? Well, for that you have already studied this case, which is the case of Dharampal Premchand. So what you had here was that out of the 45 employees that were there with the respondent, 18 had become members of a trade union. These 18 were dismissed. Okay. Now, the respondent, so this was the union, right? And this is the appellant, obviously. And therefore, these people become the respondent. So the respondent raised a preliminary objection that this was not an industrial dispute but an individual dispute, right? Because besides these 18 employees, none out of these 45, the remaining 23, were not a part of this union, and therefore this was an individual dispute rather than an industrial dispute. Of course, the court in this held that these 18 were sufficient enough for them to constitute an industrial dispute. So according to the court, this question, a small group of workmen, was also sufficient for it to constitute an industrial dispute. The next thing, again, I talk of something which has been given in a case that we will be studying ahead. It talks of a time before the introduction of Section 2A into the Industrial Disputes Act. Okay. So it says before the introduction of 2A, courts leaned in the favor of the view that an individual dispute cannot be an industrial dispute. So the courts felt that an individual dispute cannot be an industrial dispute, right? If it must be an industrial dispute, then it must be for the general benefit of all workmen or a sizable segment of them, right? However, there is this thing that has been referred to as the trade union tyranny. Now what that means is that let us say you have a certain union, okay? This is one union that consists of a certain number of people. And here is one individual. As we saw, trade unions have their own philosophy. They have their own political ideals. Now it is possible that this one individual does not subscribe to the ideology of this trade union and therefore he does not join the trade union. Okay. Now let us say this person suffers some kind of loss, some kind of individual loss later on. Now he is not a part of the union, and now if the courts do not listen to an individual, what does he do? Should he join this trade union? Now if he joins this trade union, then he is compelled to also espouse their ideology. He is also compelled to make a payment to them for membership. Therefore, trade unions started having their own kind of dominance, preventing the individuals from getting their right. So having understood this, by virtue of the amendment, Section 2A was introduced. Now, what does Section 2A do? By virtue of Section 2A, an individual workman, some disputes relating to an individual workman have been deemed to be an industrial dispute, right? So now if there is a discharge, dismissal, retrenchment or any termination of a workman, even if it's an individual workman, right, that will be considered an industrial dispute, and therefore he can seek the remedies that are available to him under the Industrial Dispute Act. Okay. So we just saw that there can also be disputes between unions. So I spoke of a dispute between a union and an individual, right? The second thing that can happen is that there can be a dispute between two unions as well, right? I'll talk again, like I said, in a bit about registration and recognition, but you understand that unions represent different ideologies. Perhaps this is the BJP union and this is the Congress union. So they might have clashes between them, which means that there is not always complete unity within a union. So when we see that there are so many problems in joining a union, why should one join a union at all? How does it help to be a part of a union? When you have individual rights, right, which have been recognized under Section 2A, when you have all of the rights under the Constitution, then why should you join a union at all? Now, the reason for that is that you get two advantages by joining a union. The first is that you get the ability to engage in collective bargaining, which means that instead of bargaining with the employer one by one, what the workers can do is that they can gain strength in number, right? So now when you have one representative who now bargains with the employer, there is a bit of a level playing field. The second thing that happens is that you receive several immunities. I'll talk about these as well. I'll talk about both of these in a bit. Coming to the Trade Unions Act. Before we talk about the Trade Unions Act, I'll talk about the legislative scheme, which is to contextualize this by telling you a few terms that have been mentioned in the Industrial Disputes Act. So what is a strike? A strike means a cessation of work by a body of persons employed in any industry, acting in combination or concerted refusal to continue to work or to accept employment. Very simple. So there's a strike, which means there's a cessation of work. Some people decide if this is concerted, this is a spelling mistake. All right. So they decide that they will collectively desist from working. So a strike basically means that some people in combination decide not to work. The next thing that you have to see is trade union as defined in the Industrial Disputes Act. And what it essentially says is that a trade union is a trade union under the Trade Unions Act 1926. And therefore, we now go to the definition of trade union as given in the Trade Union Act. So now we are looking at 2H in the Trade Unions Act. Take a moment, pause the video if you must, and have a look at what a trade union is. There are some important things that I'd like you to see. A trade union is a combination. Now, it need not be a combination only of workmen. It can also be a combination of employers. Even employers can form a trade union. Of course, it's not common for that to happen, but even employers can form trade unions. That's an important thing. The second thing is that in a trade union, there might be both workmen and employers. Again, that doesn't happen, but theoretically, the definition of trade union allows it. Also, two trade unions, so trade union 1 and trade union 2, can also have a form of federation, and this can become a new trade union 3. Okay? So you get an idea of what a trade union is. A trade union is basically a combination. That's all. Moving forward, this is a little excerpt that I've taken from your judgment. Just read this one line. It will introduce you to a few new terms. It talks about a registered trade union. So in 2H, we talk about a trade union. When we come to this here, we talk about a registered trade union, which is under section 2E. it says that the mode of registration is provided under section 4, and every application for registration of a trade union has to follow the rules that are given under section 5. Okay, so as you can see here, there are some requirements under section 4. If there are 7 or more members of a trade union, they may apply for registration. Okay, so registration is not mandatory because it says they may apply for registration. Okay, registration is not mandatory. There are a few more rules. Just have a look at section 4. The need that it should be at least 10% of the total membership. The number of people applying should be 10% of the membership, or a minimum number of 100. Just check this by your own self. Look at section 4. Likewise, when you look at section 5, it will give you some of the requirements that are needed, the names of the addresses, all of this, the trade union head office, all of this. Have a look at this. So we know what is given in 2E. 2E is registered trade union. We know what is given in section 4 and section 5. Apart from that, we will see section 11, 6 and 22 in a little while from now ahead when we see the cases. Okay, a little while back we discussed as to why a person might want to join a trade union, and the reason for that was that they will get some immunity. This is not the kind of immunity that saves you from corona, well, but it saves you from something else, right? Have a look at section 17 and section 18 of the Trade Union Act. Very important sections. This is the true advantage of why a trade union is registered. We studied some time back that when you have a union of any kind, common law or law in general looks upon such a union with some kind of suspicion that this might be an unlawful assembly that is trying to prosecute its common object, and it gets immunity from this. So these people no longer look like conspirators. So as you can see, once a trade union is registered, it gets immunity from criminal conspiracy. So it says that no member of a registered trade union shall be liable to punishment under section 120B. 120B is the punishment for criminal conspiracy, right? Unless, of course, the agreement is an agreement to commit an offense. So if you agree to commit an offense, of course you're punishable, you're liable. But anything apart from that, you receive an immunity. Okay. Similarly, there is an immunity from civil suits in certain cases. Okay. So you can see that there are certain kinds of immunities that are available to them, that there can be no suit or legal proceeding against a trade union or any of its members, right? So these are the advantages of getting registered. So registration is not mandatory. So this registration that we see is not mandatory. But if it is registered, you get several benefits. And it is for this reason that registration is desirable. Now, I had said that I'd discuss registration and recognition with you. So we've seen what registration is. Now let's have a look at what recognition is. Recognition is the process through which the employer accepts a particular trade union, right? So let us say there are many trade unions. This is the first trade union. This is the second trade union. This is probably the third trade union. Okay. We've seen that there can be multiple trade unions even within one firm, right? Even under one employer. Okay. Now, registration is not mandatory. So let us say this one is registered. Okay. This one is not registered, and this one is registered. Remember, this is registration, not recognition. I'm talking about registration as of now. Now, out of these several trade unions, right? Recognition is the process by which the employer accepts one particular trade union as having representative character, and hence will be willing to engage in discussions with the union with respect to the interests of the workers. Which means he says that okay, there might be many unions, but I choose only this one union, I choose this union. Which means that in order for him to now discuss anything, he says, I don't want to discuss with this union, I don't want to discuss with this union. I just choose to consider, by recognizing this union as the representative of the interests of the workers. So he confines himself to this one union. Now, recognition, as you can see, is something which the employer does for the trade union. Now, this can happen either by the will of the employer, or if there are some other laws that are operating. If you noticed, when we saw the CTUOs, the Central Trade Unions organizations, right? The CTUOs, those were recognized, and I said I'll discuss the word recognized later on, recognized by the Ministry of Labor, right? So those are recognized, but they were recognized by the law. The other way in which recognition can happen is by the employer. So let's have a look at this. Generally, the registration of a trade union does not imply that it has gained recognition. Very important. Simply the fact that you go and register. So we saw sections 4 and 5. Let's say you go and register. Does that mean you have got recognition? No. Registration does not imply recognition, okay, unless it has been granted by the employer. Now, there are some other situations in which you can get it, which is through some specific legal provisions pertaining to the recognition of trade unions. For example, there is an act of 1971 in Maharashtra. We will be seeing that ahead when we study the cases. So we will study that in some detail later on. But what I mean to say is that recognition does not happen simply when there is registration. Registration is something that you can get as a matter of right because there is a law for registration. Whereas for recognition, there is no central law. Very important. You have a few local laws for it, state related laws for it, but you do not have a central law relating to recognition. Okay? Kind of think of registration and recognition like this. Registration is like your right to freedom of speech. You can speak if you want to, but recognition is like your right to be heard. I hope you understand that right to speech is a fundamental right. Right to be heard is not a fundamental right. Now, for example, I am making this video for you, okay? Nobody can stop me from making this video. Nobody can stop me from speaking in this video, but I can't force you to hear this video, right? Recognition is like that. Recognition is that there are several unions. All of these unions, so you have the trade union 1, you have trade union 2, trade union 3. All of these have exercised their fundamental right to form a union. They exercise their right to get registered. Now, recognition is pretty much the prerogative of the employer unless there's a law that mandates recognition of that kind. Okay. Finally, summing up registration and recognition. Registration, it's not mandatory, but it is desirable because you get certain immunities if you are registered. This is governed by the law. By the central law, you have the Trade Unions Act. It gives you what you need about registration. However, when I talk about recognition, then recognition is not so much governed by the law. it is governed by what the employer decides to do. Okay, and recognition is an important thing, because once a trade union is recognized, then that trade union has the representative character. So now let us say this is the recognized one. The employer talks to this trade union, and then on the basis of this you decide for everyone else, right? So being a recognized trade union is again desirable, but there is no such law in general for these, no central law for these. There are state laws, but otherwise there is no law related to recognition. So now we know what registration and recognition is. Now I'll talk a bit about dispute resolution, okay, one by one. As we saw, there were two reasons why you would want to join a trade union. The first, of course, was immunity, and we've discussed immunity. The second was the ability to engage in collective bargaining. Now, what that means is that you can now bargain with the employer as a collective, as a group. I just want you to know that there are a couple of stages that this collective bargaining process undergoes. First, you create a charter of demands, which means that this workers' union, the trade union, will now list its demands. After listing its demands, there will be a round of negotiations. On the basis of the negotiations, there is an agreement that is made, which is basically a contract. So you're again coming to a contract. So again, there is a contract, but now the contract is between this group with the employer. So it's a collective bargaining agreement. Let us say this agreement is not followed, then there can be a strike. Of course, you can't simply go on a strike. Before going on a strike, you have to give a notice. Have a look at section 22 of the Industrial Disputes Act. It tells you that you have to give 6 weeks notice. So there are some requirements before going on a strike, but then you can go on a strike. Now after this strike, there can be conciliation, and if conciliation does not work out, then there is arbitration. The arbitration can either be voluntary or it can be compulsory. So you must briefly know that there are some stages that happen in collective bargaining. You don't resort to a strike immediately. If someone resorts to a strike immediately, then the strike would be illegal, right? So it's good to know as to what these stages are. The next thing that I'd like to talk about is the various types of protest. You might have heard these words. In fact, there are more words than just these, but I'll discuss a few words with you. You may have heard this word called bandh. Now, bandh means to close or to lock, right? Bandh, it's actually a Hindi word. It's this bandh. It's not bandh, it is bandh, okay? So this is one kind of protest. What is it? As the name suggests, you call for a closure of everything. I will talk about this in a little more detail when we study the cases, but you get the idea. A bandh is a closure of everything. The streets, even normal activities, everything is closed. Then you may have heard this word called hartal. Now hartal is a word that is pretty much like strike, okay? So you could say that hartal is the Hindi equivalent of strike. Not exactly, but pretty much so. Bandhs are generally almost always illegal, right? But a hartal may or may not be illegal, okay? It may be legal or may not be illegal depending on how it is carried out. Now what is a gherao? A gherao is again a violent way of doing it. A bandh is a closure everywhere, like on the streets, everything. Whereas a gherao is that, let us say if this is the industry, okay, so let's say, just to make it a little stereotypical, let's say this is your industry and this is the perimeter of the industry, and your employer is sitting inside here on his big chair and his table, Okay, this is your rich employer. Now the workmen decide that we will not let this guy go out. So what do? They do a gherao, right? Gher lena. So they confine him within this. So in a certain sense, it is a kind of wrongful confinement, right? That's a gherao. Then you might have heard this word called demonstration. What is a demonstration? Well, a demonstration, as the word suggests, is simply to demonstrate something. It's an expression, and expressions can be of various kinds. Your expressions can be peaceful, your expressions can be decent, or they could be violent and indecent. And depending upon how they are, it could be legal or illegal. And then there is strike. I will talk about strike in some detail. Strike has also been defined. We saw that the strike is a cessation of activities. Now, how do you do the cessation? There are various ways of doing it. There are certain rules that have to be followed. We will talk about that in some detail. I also want to just talk of this word called lockout. What is the difference between say a strike and a lockout, or a bandh and a lockout? Well, all of these five, the ones that we've seen here, let's say if we talk of this and this, these are done by the workers, by the workmen, right? These are done by the workmen. However, a lockout is something that is done by the employer. Okay, I just wanted you to know this little difference. Of course, you will find more such words in Hindi relating to such closures, but you get the point. This is briefly as to what kind of types of protests you can have. Moving ahead, like I said, we'll talk in little detail about strikes. The first kind of strike that you can have is a general strike. Okay, so everyone decides that we will go on strike. There's a proper notice that is given. You follow the procedure. You follow the requirement under section 22 and you go on strike. Another way of striking is to go on a mass casual leave. As the name suggests, everyone decides that they will take leave on a certain day, and that becomes a strike of its own. In this case, which is also sometimes called the tools down kind of strike, you don't take leave. You go to the office or the workplace. You stay in, sit down and keep your pen down or your tools down. So you do not work. You go but do not work. Another way of doing it is to go, you work, but you work extremely slowly. Go slow is another kind of strike. A token strike is a kind of strike which is kind of nominal, which means that they don't really strike so much. They pretty much do all of their work, but the strike is a token strike. Let's say, just for example, like wearing a certain badge, or perhaps not working for a very small part of the day. It's a token strike, just to show the protest. The next thing is a lightning strike. As you can see, a lightning strike happens without notice, and therefore, according to the Industrial Disputes Act, a lightning strike is illegal because it gives no notice, right? A sympathetic strike is a strike that, let's say, there are some people who are aggrieved. Okay, there are these two people who have been aggrieved by the by some decision of the employer. Okay, now out of sympathy for these people, the rest of them decide that we will go on strike. So you can have a sympathetic strike as well. It's a case where some of the other members empathize with these people, and out of sympathy they go on strike and join them. Hunger strike, needless to say, simple. It can acquire an illegal character, because at some point a hunger strike becomes attempt to suicide, but until it goes there, a hunger strike is generally not illegal. This is something very peculiar. Work to rule. You might realize that when things happen very strictly according to a rule, it starts creating problems. So that's what the workers do. They start paying attention to very minute, tiny rules. So they start working according to tiny, minute rules. and that tends to stifle the process. So when you start following the rules too closely, the process gets hindered. That's the work to rule. And then you can have mass resignations. Okay, now I'll talk about constitutional conflicts. What I mean to say here is that you have certain rights that have been given to you under the Constitution, which basically constitute the right to freedom, right? Let's have a look at the provision, of course, Article 19 of the Constitution of India. 19(1) gives you the right to freedom. Just have a look at A, B, and C. These are the ones that are relevant for us. Freedom of speech and expression, to assemble peacefully, and to form associations or unions. As you can see, 19(1)(a), B, and C are relevant as far as our trade unions are concerned. However, what we know is that 19(1) gives you some rights, and the provisions thereafter, 19(2) onwards, they limit it. Okay, so let's look at the limitations, which we understand as the reasonable restrictions. This is 19(2). Okay, it restricts what is given to you in subclause A. So what is given in 19(1)(a) is restricted in 19(2). In 19(3), there is a restriction on what is given in subclause B, as you can see here. Okay, and then in 19(4), there is a restriction on what is given in subclause C. Take a moment to have a look at these. You will see that there is some commonality, right? All of them talk about reasonable restrictions, right? Here, reasonable restrictions. That's the first thing that you see. We all know that there are reasonable restrictions that can be imposed on our fundamental rights. Apart from that, I want to draw your attention towards a very important word that is again common between the three of these, right? And that commonality is public order. You see public order here, public order is here, and public order is here. So we see that there is public order in these three. Now, what is public order? Okay, I find again, this is an excerpt from one of the judgments that you will be studying eventually, but this is a very beautiful way in which public order has been expounded. Okay, so what he says here is that the state is at the center, right? The state is at the center and the society surrounds it. The state is at the center. Let me just draw that for you. Just a second. Yeah. He says the state is at the center and the society surround it. He said disturbances of the society go in a broad spectrum, from mere disturbance of serenity of life to the jeopardy of the state. So he says that disturbances can be of various kinds. In its mildest form, in its most simple form, it can simply mean disturbing the serenity of life, right? So he says when it is mild, it is simply disturbing the serenity of life. And when it becomes more intense, right, in its graver forms, it can mean the jeopardy of the state. So even if you look at this here, you can see that there's this phrase, and the phrase is security of India, the security of the state. You can see that it's a word that connotes greater seriousness, security of the state. Right here you can see security of the state. And then there is public order. So when he's talking about the state and the public order, what he says is the acts become graver and graver as we journey from the periphery towards the center. So we saw that we have the state at the center and the society surrounds it, and as we come towards the center, the acts become graver and graver, right? So he says that in this journey, we travel first from the offense of public tranquility. If you might notice, there is this entire chapter in the IPC, the Indian Penal Code, which deals with offenses affecting the public tranquility, right? Tranquility is basically peace. Like he said, serenity. Yeah, serenity. Tranquility is basically serenity. He says, so the mildest form, according to him, is what affects the public tranquility as you go towards the center. Next, he says you have public order, and then you have the security of the state. So he says that public order is basically here. It is not as grave as a threat to security, but it is not as mild as public tranquility. So this gives us an idea of what is understood by public order. Now, we have reached our cases. These are 6 cases. I'll go through them one by one, and hopefully by the end of this, you should have understood what is required for us to be learnt in the Trade Unions Act. Let's take the first case, the first of our 6 cases. Okay, so this is it. Again, now when we do these cases, I require you to pause the video and read what you see on your screen. I will always assume that you have done so, and therefore I will keep the pace of the class up. Otherwise, this video will get very long and I don't want to do that to you. So you need to pause the video wherever you find it necessary in order to be able to understand what you need to. Okay, so there are 2 unions of workmen, okay, in the company. So we've seen that there can be more than one union. So here you have 2 unions. This is the first union and this is the second union, and they are at loggerheads, and there is their inter se rivalry, which means this is a rivalry between trade union 1 and trade union 2. Okay, let's going ahead. The appellant, that means this person here, is the non-recognized union. Okay, so we remember that you can have unions can be recognized or not recognized. This is the not recognized union. Okay, it is challenging the validity of section 20 of the Maharashtra Recognition of Trade Unions Act of 1971. If you remember, I told you that we will see a Maharashtra law of 1971 that deals with the recognition of trade unions. Well, this is that act. Okay, so the non-recognized union is challenging the constitutional validity of this provision. What is the provision? We'll have a look, don't worry. To this petition, they impleaded the employer company and the other union, which is the recognized union. So what do we have in this case? We have the unrecognized union versus the employer and the recognized union. So this is the employer, and this others here refers to the recognized union. Now what are the facts? There was a settlement that was arrived at between the employer and the recognized union, right? So now the recognized union is the union with whom the employer talks. Okay, so he resolved a dispute between them. The settlement is of course like a contract. Okay, in that contract you have clause 17, which is one of the clauses. Let's have a look at what clause 17 say. Again, like I said, pause the video from time to time. I will not repeat this for you now. I will assume that you are pausing the video. This is meant to be a quick, fast video so that your time is not wasted. Okay. Anyway, so clause 17 says that each workman, as you can see, the main point in this clause is that they will have to contribute 15% of the gross areas that are payable, as a contribution to the union fund, which means that each worker has to pay some amount of money to the union fund. Now this is the problem, this is where the problem has arisen. Okay. The non-recognized union said that this settlement which has been arrived at between the employer and the recognized union. So we have two unions, we have the recognized union and we have the unrecognized union. These are the two unions we have, and we have the employer. Now the agreement has happened between these two people. Now what he says is that now even those from the non-recognized union have to make this deduction of 15%, right? Even when they didn't want to. So they are saying that they don't want to make this 15%. So the point is that they are saying that whatever might be the agreement between these two persons, they don't want this to affect the unrecognized union, and therefore they have come to the court saying that this agreement is not okay, this clause is not okay. So the contention of the appellants is that this section 20 violates the fundamental freedom to form an association guaranteed by Article 19. Section 20 basically is the provision in which act? In the 1971 Act. Do not get confused, you will not find this in your Trade Unions Act, you will not find this in your Industrial Dispute Act. This is the 1971 Maharashtra Act. Now what this section does is that it allows for one of the unions to be recognized. Okay. So now the contention of the appellants is that suppose there are two unions, Trade Union 1 and Trade Union 2, and this is the employer. If one of these is recognized and their negotiations happen between these two, this is discriminatory because you are giving unequal treatment to the unrecognized trade union. So they are saying that it is violative of Article 14. This is the contention of the appellants. Similarly, they are saying that 19(1)(a) is violated because they are not getting a chance to express themselves, because now the expression is happening. So we have Trade Union 1, Trade Union 2, and you have the employer. All the exchange is happening between these two people. This person, Article 14 is violated, Article 19(1)(a) is violated, and this is their contention. Have a look at section 20. Okay. It tells you as to what the powers are. It tells you that basically there are some rights of a recognized union and the unrecognized union does not have those rights. Have a look at it. I will not go over these. Okay, so now with regard to this, what was the decision of the court? The decision of the court was simple, as we discussed. There is a right that is given to a person under 19(1)(a). Okay, and that right is to express oneself. The trade union 1, let's say the one which is not recognized, it definitely has this right to freedom of expression. This has not been taken away from it. It continues to enjoy the right to freedom of expression. There has been no unequal treatment to it, because whether to recognize, so let's say we talk of the employer. Okay, now the employer has, let's say he has Trade Union 1, he has Trade Union 2, he has Trade Union 3, there are Trade Union 4. Now the employer cannot really talk to each one of the trade unions, and therefore he chooses, let's say, one of these as the recognized trade unions. This is not a violation of the right of these three, because these people continue to have the right to speak or the right to freedom of expression. They have all the immunities. If they are registered, they have all the immunity. They enjoy all their constitutional rights. What they do not have is the recognition by the employee, and like I said, there is no right to be heard, right? You don't have a right to be heard. I like to again talk of this example. The example being that there is a Supreme Court judgment that under Article 21 gives you a right to be married, to get married. So you have a right to marry. Okay. Now, does the right to get married mean that that someone else is given the duty to refuse, or the right? Does that mean that suppose you have the right to get married, does that mean that nobody can refuse you in marriage? That's not what it means. It means you have a right to go and ask someone to get married to you. If someone refuses your proposal or refuses to your proposal, that is not a violation of your right. Your right continues to exist. So that was the decision of the court. The court held that there was no violation of Article 19 or Article 14. So this is the first case. We're done with the first case. Let's go to the second. Here, the meaning of a bandh is discussed. Okay. One second, there appears to be a bit of a mix-up. So basically giving you the decision of this court that conferring, so this is the first case again. There was a bit of a mix-up, so I'm sorry for this. We're just continuing from there. The court held, so I've given you the contentions of the appellant already. Okay, the color code is helping us. Conferring the status of a recognized union does not deny the right to form an association, which means 19(1)(c) continues to remain. The members of a non-recognized union can fully enjoy their fundamental freedom of speech. They enjoy 19(1)(a). Okay. Then there was another contention of the appellants, which was that non-members are subject to a compulsory exaction. Exaction means that they are being compulsory required to pay that 15% to a union whose philosophy is not in agreement. Like I said, you can have one BJP union and the other could be a Congress union. Is it fair that one person has to pay money for the other? This is the contention of the appellants, to which the court held that it is unfortunate that in some cases resorting to strike has become an industry. So what happens is that, let us say a few workmen want to go on strike. Now if they want to go on strike, it means they will not get wages during this time, right? So during this time when they are going on strike, they are given some money by the trade union, right? So you do not get wages from the employer. So how do you continue to remain on strike? So he said that the unions invest in sustaining the morale of workmen during the strike when the employer denies the wages, which means that workmen who cannot stand up for want of wherewithal or cushions, the trade union may help them by giving some monetary assistance. So if a person has to contribute 15%, the court held that paying this 15% is legitimate. It is not something that violates their right to freedom of expression or faith or associations. It affects none of their rights. This is basically a charge that is paid to the union because the union also pays them when they are in need, and therefore the court held that the appeal here must fail. Okay. Now we come to our second case. So I will go back to the purple slides once again because a couple of slides have been misplaced here and there. I'll go back to that in a bit. So this petition basically seeks the relief of a declaration that the calling for and the holding of a bandh is unconstitutional and hence illegal. According to the petitioners, bandh is extortion, violence, physically restrains people, and therefore it is a violation of the rights under Article 19. It also prevents them from carrying out their freedom to carry out their trade. Okay, just make sure you read this. So they said that since it causes several things like terror, national loss, etc., destruction, these illegal acts in a Bandh cannot be recognized and protected under Article 19. So the petitioner basically wants the court to declare that Bandh is unconstitutional and illegal. This is what the petitioner wants. Okay. Now, what is a Bandh? Okay, you can also have a look at a couple of more things. So the workers are prevented from attending work. 19. He also said that political parties cannot be held responsible because they don't prevent people from doing so. And he said that therefore the Bandhs have to be called illegal. Just have a look at all of this. It's very simple. The state does not take measures to prevent it. And he says since the state and the machinery does not really help, he is compelled to knock the doors of the court. Just have a look at this as well. Now, what is a Bandh? I've discussed this with you earlier. A Bandh is basically a general strike, is a call for closing everything. It is not like a strike. It is not like a, what is written as a hurtle is actually basically a hartal. You will find that it is misspelt in your Manupatra judgment. Okay. So he says that the intention of the callers for Bandh is to ensure that no activity is carried out. Okay. So you cannot get your newspapers, you cannot get hospitals, you cannot get milk. Now, what the Advocate General, who was representing the state of Kerala, said was that it is possible for a Bandh to be carried out without violence. Okay. But what the court said was that even if there is no threat, express or implied threat, there is always a menacing psychological fear that exists when you have a Bandh. Okay. So he's saying that when there is a Bandh, there is always a fear instilled in the mind of the citizen. And they have also cited a case which says that even a psychological restriction is a restriction on the fundamental right of a citizen. Okay. There is no definition of a Bandh, but we do understand the meaning of a Bandh, and simply the absence of a definition does not mean that it cannot be called unconstitutional, right? People have certain rights. People have the rights to roam around, to move around as they please. And if there is a Bandh, the exercise of these freedoms will come to an end, right? Therefore, the decision of the court was that it agrees to the petitioner and declares that a Bandh is illegal and unconstitutional. This is the third case. Okay. The short question for determination in this matter is whether an employee, as a result of cessation of employment, would lose his right to continue as a member of the trade union or not. What does this mean? Let us say this was a trade union. Okay. Now, one of these persons loses his employment. He is no longer an employee. Does he still remain a part of the union or not? This is the question. Okay. Now, let's see what happens in this case. This is, of course, before the Supreme Court. Now, what had happened before this? The High Court, single judge, said that even if it is terminated, so even after a person has gone out of employment, he remains a member. Okay. Then the larger bench of the High Court, the division bench, which means two judges, the two-judge bench said that no, you cannot be a member of the trade union once your employment is ended. And now the matter has come before the Supreme Court in appeal to decide. Okay. All right. So now, of course, the union is the appellant because now we are in the Supreme Court. I said that we'll discuss section 6 later on. Here's the time. We're discussing section 6. Section 6 gives you certain requirements for registration. Okay, pause the video and read section 6. I assume you will do it, and that's how I proceed. I assume that when I tell you to pause the video, you are pausing the video. The admission of ordinary members shall be people who are actually engaged or employed in an industry. Okay, that's a key word that we see here. Okay, actually engaged or employed. Okay, similarly, if you look at section 22, you will find that it talks of people who are actually engaged or employed in an industry in which the trade union is connected. Now, why I'm giving emphasis here is that once there is cessation of employment, which means a person is no longer an employee, he is not actually engaged or employed. So this is the question that we are discussing in this case. Also, the constitution of the trade union has a clause 5, okay, which talks about the membership. So it talks about what the worker should do in order to be a member, that he should pay a certain membership fee and all of this, he must follow the bylaws, etc. Now what the court held was that section 6E and clause 5 of the constitution provide the terms of admission of membership. They do not provide the terms for its cessation, which means that in order to get into the trade union, if you want to get into the trade union, you need to be actually employed, right? So if you're actually employed, you get into the trade union. But nowhere do they say that, let us say, if you are no longer an employee, your membership ends. This has not been spoken of. They said 6E and clause 5 only talk of the terms for admission. They do not talk about the terms of cessation. Therefore, in the absence of any such provision, it cannot be held that an employee would cease to be a member in an eventuality. In other words, they felt that the decision of the single judge of the High Court was right, and they reversed the judgment of the division bench of the High Court. Essentially what they said was that, let us say there's a person, he was a member of a trade union, this person goes out of employment. Despite not being an employee, he continues to be a member of the trade union. This is the point that was stated. Case number 4, it talks of a question. The question is about a rule that was made for the government servants in the state of Bihar. The rule says that no government servant shall participate in any demonstration or resort to any form of strike with regard to any matter pertaining to his conditions of service. We've already seen these two words before, demonstration and strike. I said that I'll talk about demonstrations a bit more. Okay. Now, this is a case that had come from the Patna High Court to the Supreme Court, right? This is a case before the Supreme Court. It had come from the Patna High Court. Okay. Before the Patna High Court, the contentions of this union. So now the appellants here are basically a union within the employment of the government of Bihar, to whom this rule applies. So this rule applies to the government servants, right, who are working for the government of Bihar. So now there is a representative who has come before the court stating that this rule which prevents them from resorting to strike is illegal. Okay, so he wants that to be struck down. So now before the Patna High Court, it was held that, it was contended that it interferes with their right to 19(1)(a), (b) and (c), and also this rule that was made, this rule 4A, which was made under Article 309, was an in excess of the rule making power that is given to this body, right? And I'll talk about 309 in a bit ahead. So they said they wanted an order to restrain the respondent, which is the state, from giving effect to the rule and resist from interfering with the petitioner's right to go on strike or hold demonstrations, which means they said that let us please have our right to go on strike and to hold demonstrations. The Patna High Court said that there was no such right to strike or right to demonstrate as far as government high courts were concerned. So the Patna High Court said that the rule 4A is completely fine. You're a government servant and you do not have these rights under 19(1)(a), (b) and (c) to the same extent as someone else. They held that these were reasonable restraints. However, they said that you can go in appeal to the Supreme Court. I hope you know what a certificate under Article 132 is. So, in order to reach the Supreme Court under Article 133 in civil matters, like this is a civil matter, you need a certificate of fitness from 132, whereby the High Court certifies that this is a matter that needs to be or that can be heard by the Supreme Court, or that it contains a matter as to a substantial question of law as to the interpretation of the Constitution. Okay, so this certificate has been given by the High Court and then they come to the Supreme Court. So Article 309 basically says that subject to the provisions of the Constitution, the legislature may regulate the recruitment and conditions of service of persons appointed to public services. What that means is, under 309, the appropriate legislature can regulate the recruitment, which means they can make rules under 309. The contention of the appellants is that while exercising this power, they have gone excessively in doing this, and therefore they have transgressed the rule making power, because the rule making power is subject to the provisions of the Constitution. So they are saying that the appellants are saying that the state of Bihar has gone beyond its power. Okay. Now, what we know is that under Article 13, every law must be consistent with Part 3. Part 3 is fundamental rights, which means that if there is any law which is inconsistent with Part 3, then that law will not survive. If you don't know what Article 13 is, go look at it. If you don't know what Part 3 is, go look at it, right? Don't bother, I'm going fast, but that doesn't mean that you can't pause the video and see things for your own self. All right. So this thing is a law. So under Article 13, you can see that a law is a very broad term under Article 13, and therefore it was held that this is also a law, right? And therefore this has to be consistent with the Constitution. And the contention was that since it is inconsistent with the provisions of Part 3, it would have to be pronounced invalid. This is what was demanded by the appellants. Now I'll talk a bit about demonstrations and strikes, because this Rule 4A talks about both demonstrations as well as strikes, right? As far as a strike is concerned, is there a right to strike? The court said no, there is no right to strike. Fine. Now what is a demonstration? A demonstration, as you can see from here, is basically just an expression. Now this expression can be legal or it can be illegal. Similarly, you do not have a right to strike, but you can go on strike, because a strike could be illegal or a strike could be legal, but it cannot be said that you have a fundamental right to strike. There is no fundamental right to strike, and this has been stated in this case. Okay. Now, a demonstration, like I said, could have both violent and peaceful forms, right? So it means that if there is a peaceful form of demonstration, this would fall within the freedom granted by 19(1)(a) and 19(1)(b). Okay. But if it is noisy, disorderly, stone throwing, etc., it would not be within 19(1)(a) or (b). This is what the court has held, that if the demonstration is violent, it is not protected by the fundamental right, but if it is peaceful, it is protected by the fundamental right. Right? It can be peaceful. Some people may just wear a badge. That's all. It's very peaceful, and this is something which is protected by under Article 19, 1A and 1B. Another contention that was raised was, are government employees a different class? Because here this has been established that demonstration cannot be denied, the right to demonstration cannot be denied. So now the contention was raised by the respondent, whether government employees are a different class. Does that mean that although everyone has the rights under Article 19(1), can you make a different law for the government employees because they are a different class? As you're aware, it is possible to make laws for a different class following the nexus test. If you don't know the nexus test, Google it. The nexus test consists of the test of intelligible differentia and then rational nexus. Right? It's a test that you've studied in constitutional law, Anwar Ali Sarkar versus the state of West Bengal. Make sure you Google that. With regard to this question, the court looked at Article 33. Now what they said was, Article 33, as you might appreciate, so 12 to 35 is your part 3, which contains your fundamental rights. Immediately after 32, which gives the writ jurisdiction, the right to constitutional remedies, you have Article 33. What Article 33 says is that you could restrict or abrogate the rights of certain people, right? Who are they? They are the members of the armed forces or the members of the forces charged with maintenance of public order, like the police or the allied forces, right? So now there are a specific list of government employees who are given here. So you cannot say that all government employees are a different class. The different class has been specifically stated. Therefore, the answer to this question, whether employees are a different class, the answer is no. Only some government employees are a different class. So they said that we therefore appeal the allowance part, which means, what is the part that is allowed? The part that is allowed is that prohibiting demonstration is wrong, right? Because people have a right to demonstrate. However, it said that as far as the prohibition of strike is concerned, well, that can be done. It is always possible to prohibit a strike. Therefore, they allow the appeal in part, which means your Rule 4A spoke of both demonstration as well as strike. So, and the appellants wanted both of them to be taken down. They said we can take down demonstrations, but strike will remain. Let's go to the next case. This is a petition under Section 11 of the Trade Unions Act. Have a look at Section 11. You will realize that Section 11 is a section that is used if there has been a refusal to register your trade union. So let us say if your trade union has not been registered, then you get a then you get a remedy under Section 11 to approach the High Court under Article 226. What does that mean? Let us say you follow the provisions of Section 4, Section 5, you go to the registrar and you want to have your trade union registered. Let us say we cannot register it. Okay. Then now you can file a petition under Section 11, right? Whereby you can approach the High Court under Article 226 that your that your petition, that your request for registration has been rejected, right? Your application for registration has been rejected. So this is what has happened here. So the employees of the Madras Raj Bhavan as a trade union, this has been rejected by the registrar. So these people have come before the Madras High Court. Now, who are these people who have come before the Madras High Court? These are people who are employed in various capacities at the Raj Bhavan. The Raj Bhavan is basically the house of the governor, okay? As household staff, peons, chauffeurs, tailors, carpenters, mastries, gardeners, sweepers, etc. At Gindi is one place in Chennai. There's another place called Uttakamund. So there are also gardeners and mastries at the Raj Bhavan at Uttakamund. They are again used for doing some domestic services and other things. And now, the point is, can these people who are partially on the government rolls, some of them are on the government rolls, some of them are not. You can have a look at the details in the case. Can these people be said to be working in an industry, right? Which means, can they form a trade union and then can they get it registered? This is the question. When they went to the registrar here, there was a refusal. The refusal happened because he said that they were not an industry. So this is the question that now has to be settled by the Madras High Court. So as you can see that these people whom we had spoken of here, they created a union called Madras Raj Bhavan Workers Union. Now anyone can form a union, that's not a problem. The problem is whether a person who has formed a union So as you can see that these people had made themselves a union, right? And they wanted to secure better service conditions, etc. Okay. So now once they applied for the registration of their trade union, right? This was rejected. As we saw, the registrar was of the view that before a union could be registered, they must be connected with an industry or a business of an employer, and that in the present case, these employees could not be held to be workmen and therefore they could not have their registration, as we just discussed, right? So now, when they approached the High Court, they contended that the definition of an industry was very wide. As you have seen post the Bangalore water supply case, an industry does not require to be a commercial activity. So they held that given that an industry has a wide definition, even what they were doing as the chauffeurs and the masons and the mastries was also an industry. Now here's what the court said, that there are two distinctive features of an industry. Okay, I've taken this from the judgment. It said the first is that the employer as well as the employees should be engaged in the industry. The second is that there should be cooperation between the employer and the employee in achieving the particular result. But in this particular case here, there is no such cooperation between the employer and the employee. Therefore, they held that the employees were discharging a personal work, right? There is no cooperation, there was no target that is characteristic of an industry, and therefore even the High Court held that this is not an industry, and therefore they held that this trade union could not be registered. You must remember that anyone can form a trade union, because forming a trade union is a right under Article 19(1)(c). Anyone can form a union, but for registration it must satisfy some criteria, and in this case, since it was not an industry, the trade union could not be registered. Alright. We now move on to our last case. This is the Vimhans Hospital, Vidya Sagar Institute of Neuroscience. It's called Vimhans. Okay. So obviously this is the hospital versus the employees union. Now, as I discussed, is a strike something which is legal or is a strike illegal? Depends. strikes may be legal or strikes may be illegal, right? The legality of strikes depends on how it is carried out. This is a case which deals with that subject. So now there's a strike. Take a moment, pause the video and read this. Always pause the video when you see something. Of course, we've reached the end of the video now, so doesn't really mean much for me to say that. Okay, so there's a strike that has been threatened by the employees union. Okay, and of course the hospital has said that he wants the court to declare this as illegal. Okay, and he says that prevent them from doing any dharna, slogan or anything which prevents the ingress or the egress of the plaintiff, which means the entry or the exit of the plaintiff, and any other such kind of activity within a distance of 500 meters of the hospital. So basically, what is the plaintiff saying? The plaintiff is saying that the trade union will carry out a strike. He is requesting the court, please declare it as illegal, and if they must do anything, if this is my hospital, Wim Hans Hospital, let them do it beyond a distance of 500 meters. This is what he has asked of the court. Now, there are some of the things that the court has observed. It said that the immunity given under section 18, as we saw, there are immunities given under section 17 and section 18. So the immunity under section 18, if you remember, was civil immunity, which means it does not give immunity for things which may amount to an offense, right? First thing. However, a peaceful demonstration is a fundamental right of the employees. Okay, so it makes a distinction between a strike which is not peaceful and something which is a peaceful demonstration. A peaceful demonstration is a fundamental right under 19(1)(a). Okay, it says that it is the legitimate right of the workers to make legitimate demands, and then they can go on a peaceful but legal strike. Okay, however, in exercise of such a right, it cannot disrupt the functioning of the employer. Okay, and they cannot indulge in acts of violence, physical assault, intimidation, threats, etc. Because the moment they do that, it starts to acquire a criminal character, which is not permissible. Okay, it says there is no right to hold demonstrations at the residence. So a peaceful demonstration can be carried out, but you can't do that inside the residence of the employer. Okay, Schedule 5 Entry 6 of the ID Act specifically says so, which means that you cannot have even a peaceful demonstration as a matter of right at the residence of the employer. So these were some of the observations made by the court. Okay, now on the basis of that, the court said that this is a hospital, patients need to come and go, so you can't trouble them. Okay, and patients will need some solitude and peace, and therefore, since this employees union can carry out a peaceful demonstration, it's their right, they must do so at a boundary of 200 meters. So if this is the Wim Hans Hospital, they said you can do it at 200 meters. Of course, the plaintiff wanted 500 meters, but the court granted it for 200 meters. This is a decision of the court that you can do it peacefully, but do it at a distance of 200 meters. Again, this is the last paragraph of the judgment. They have just paraphrased the same thing. You can read this. And with this, we are done with everything. As far as the summary is concerned, like I said in the beginning, we might do it perhaps. So what I want you to do is that if you have reached the end of this video, think of all of the provisions that we considered in this video, the provisions of the ID Act, the provisions of the Trade Unions Act, the provisions that we read from the Constitution of India. There was one provision that we also saw in the Maharashtra Act of 1971. Just recollect those. As far as the cases are concerned, we saw 6 cases principally, but we also saw a few more cases within the cases. Just think if you can recollect those. I hope this lecture was of use to you. Thank you.